Well, good afternoon, everyone. I'm David Glaser.
And I'm Katie Ilten.
And we're here to talk about basically practical tips for dealing with appeals. You're getting information from a RAC, a ZPIC, a PSC, a BISC, which is one of my favorite.
That's a new one.
Sounds
appetizing.
Bureau. It does sound appetizing. We're going to walk through those sorts of appeal tips. As always, we have just a handful of administrative things to deal with. First off, if you want to type a question, and we really, really like questions, you should see a chat box. If for any reason your chat box goes away, depending on whether if you slip into full screen mode, sometimes you have to hover over the very tippy top of the screen, and right in the middle, you can see some arrows usually pop up. If you click there, you should get your chat box back. Upcoming webinars. We are uncharacteristically planned ahead here. So the April 10th webinar is going to be a little different. Deb Linder is going to talk about what people need to know. It's kind of the pay or play part of Obamacare. What you need to know as an employer about benefits. And so for many of you guys on this call, this is probably not a webinar that will appeal to you, but there's going to be someone in your organization who cares about this a lot in kind of benefits or HR. So we'll be sending out the description on that shortly, but that will be, several of us have heard this talk before. And it's
excellent.
It's interesting. I learned stuff. Then in May, on May 8th, we're going to do 340B pricing, and that will be done by Heather Campbell from our Des Moines office and Catherine London. We're going to take a month off in June because we're a webinar ahead, and then in July we'll be doing HIPAA. All right, another big thing, all of you probably noticed, our webinars are free now. We're a little worried because we're afraid that people will think free means that we don't have any substance in there, but we hope to be...
We'll be the judge of that,
yes,
I suppose.
Exactly.
We won't be changing the substance.
So they're free. Okay, so we're going to start with some process tips and end with some legal arguments. And Katie and I are going to just sort of dive through this. We've been doing a lot of these things together, and we're going to kind of just do this webinar the same way. So the first thing, and this is before the letter even arrives, you have to get your staff used to the idea of directing the letters to one contact person in your organization. And one of the challenges is these letters come from organizations that don't necessarily sound like Medicare. It might come from Advance Med or Palmetto. One of my personal favorites, Maximus, which sound like it's a prophylactic brand or something, or Tri-Centurion. And so you can get these letters that don't scream, we're from the government. And they sometimes get lost. Most of the letters will say Medicare on the return address someplace in small letters, but they don't always.
And it might say CMS.
Yeah.
And that's
it's not clear.
Clear to everyone.
And so getting your mail people to really understand that is, I think it's more complex. I think most people on the phone probably know that, but operationally, I can say a lot of these have gotten lost.
Yep.
Now, a thing that is not as obvious, whoever gets the letter has to keep the envelope and date stamp it. Why? The most extreme example of a problem I've seen is a letter that was dated July, I think it was 15th, and postmarked September 17th, which it turns out aren't that close. And the way appeals work is you get all of the time periods run from receipt. Most of the time there is a presumption of that receipt being 5 days after the letter was mailed, and that is a rebuttable presumption.
Right, and actually the receipt is 5 days after is the date of the letter. They assumed you received it.
Correct.
So if the date is July 5th, they assumed you received it July 11th, but then you actually got it.
And so there are a couple things you want. So you want a date stamp so you can prove when you received it, and you want to keep the envelope so you can show when it was mailed. So those are both, and you just have to make whoever's opening the mail get in the habit of doing those two things.
And I think just to be safe, it's best to run your time frame for appeal, which we'll talk about what those are, from the date of the letter so that there's no contest about whether you got your appeal in on time. So if you can do that, do that.
And we're big fans of not getting to the last day, but people do. On the other hand, if you're getting close, you should know of what you can take advantage of, and what you can take advantage of includes, there's this presumption that you didn't get the letter till 5 days after it was sent, and in fact, that's true. That presumption really applies, arguably, even if you got it earlier.
Right. All right. So once you get a letter telling you that you've been overpaid, this is when actually, I'm going to back up because it's unfortunately not that easy. You might get a letter from one of these weirdo contractors that says, you've been overpaid $800,000, which isn't, sadly, an uncommon amount. And then it will go into how they figured that out a little bit. And then it won't tell you anything about your appeal rights. And so you're sitting there with this letter and you're saying, I've been overpaid, but what am I supposed to do about it? The demand letter will often come separately. And the demand letter is the one that starts your time frame for appealing. So you might get 2 letters with an overpayment amount. You have to pay attention to which one is saying, this is the determination that's going to start your appeal time.
And Katie's point is super important. I know there are at least a couple of people on the call right now who are sitting with letters with demands, like I think one of them is bigger than the $800,000,
Right.
and they're wondering, we've been telling them you can't appeal yet, and they're kind of going, but we've got this letter. And they do, but you basically can't appeal
Right.
until you get the demand.
Now, that doesn't mean you can't start getting ready to appeal, because if they think you owe $800,000, they're probably going to ask for it sometime. So use the time you have. So once you get the initial determination, that demand letter, you basically start on a road of 5 different levels of appeals if you need to go that far. And so we have those appeals here. We're going to actually walk this webinar through just one level at a time, so that if you ever find yourself in this position, you could pick up these slides and just figure out what to do based on them. So the first level where you appeal is called the redetermination. So you're going to be requesting a redetermination. These are not terribly original names. Your timeline for doing that is 120 days from the day you receive that demand letter to submit your request. Now, there are a couple funny time things here. You have the 120 days to appeal. If you submit that appeal letter within the 120 days, it's still good. But in order to make sure that the contractor doesn't start recouping money that they think you owe, you need to get your appeal letter within 30 days after you receive it. And actually, I would suggest, if you really want to make sure recoupment doesn't start, I'd say 20 days, because basically contractors, the right hand doesn't know what the left hand is doing. So if the right hand says go ahead and recoup, and then your letter comes in on the 29th day, they might start recouping anyway, and now you have to get them to stop.
Yeah,
so basically shave your timeline in half.
A couple of points on recoupment. One is, if they recoup any money, basically it's almost impossible to get them to return that recoupment short of winning the appeal. It is, however, possible, and I can't count the number of times it's happened, to get them ultimately to stop the recoupment. I think it's gotten better lately.
Depends on the contractor.
But years ago, it used to be a 100% fail rate. They would continue to recoup. Now, I'd say 75% of the time, they stop recouping.
Right. And now, this is also not to say that if you submit your letter on day 60, that they still have to stop recouping, but it's much easier to prevent them from recouping in the beginning than to stop them, because basically you're going to be paying your lawyer or somebody on your staff to call them and hound them until they stop.
And so you and then you just don't get the money back from that day 30 to day 60.
Right.
And they'll hold whatever they're supposed to pay you, up to the amount. So it may even be done. The other thing is, sort of from a practical level, you may not have the letter you want done in 30 days. And if we're talking about, like one rack case, who cares? Recoupment is moot. This is really when we're talking about the $1 million or the $300,000 cases that this matters. In that situation, what we'll often do is use a placeholder letter. And so you send in a letter within 30 days that says, we're appealing. We'll be sending in a subsequent letter with more details. Now, the bad thing you need to know about that is, not infrequently, they'll treat your initial letter as the request, and sometimes before you get your letter in, they'll make a decision. I don't know that matters that much, because you're going to lose anyway.
Right.
But that placeholder letter is a good option.
Right. Okay, so when you get your demand letter, or even before it, if you know about the overpayment allegation before, you want to start thinking about who is going to be on your appeals team. And David and I highly recommend careful thought about this. The reason you want to identify your appeals team early is because it helps you the most to have everyone involved from the beginning to the end, so that your process is more efficient, fluid, and people who will end up testifying before the administrative law judge at the end know what's going on at the very beginning.
From a practical standpoint, we've had a bunch of situations where you get a physician who's getting ready for the hearing, reads the letter, and doesn't like something that's in the letter. And that's a problem. And in fact, I would add, not only get a team that goes consistently through the whole thing, you want the same team. I place a great value in having a set of people And depending on the size of your organization, it may have to be a fairly big set of people, but maybe you can be small, that do all of the appeals. And so one of the questions that comes up is, do you want to use the physician who was involved in this particular case, or the practitioner involved in this case, or do you want to use a kind of, quote, standard physician? And we're proponents of the standard physician. If you need to get supplementary testimony from the treating physician, you can do it, but it's, I think, helpful to have one person who learns how to do the testimony, gets it, and you can figure out kind of collective styles and go at it that way. So there isn't obviously a legal reason to do that way. Just from our experience, I think having one physician who gets used to testifying has lots of upside. But the bottom line is whoever is going to be testifying at the ALJ hearing needs to be involved early in that letter writing process so they're comfortable with where you wind up. Now, gathering the record should be pretty easy, but all kinds of things come up. The first one is this myth, and it's endemic. I've heard it for years and years and years. People seem to think that if you have records from an outside facility, those are somehow not part of the medical record. And so if someone requests the medical record and you're Clinic A and you have records from Hospital B, you would never send Hospital B's records along with the request for information or part of the appeal. And that's just wrong, and it's really baseless. And it can get you into trouble, because often that outside information explains the thought process of the medical professional. So that's a belief to stomp out of your medical information department. Another question that comes up is, let's say they've asked for records from 2009, and you have to decide, well, they didn't ask for anything from 2008. Should we send anything from 2008? There are competing philosophies on this. One is don't give them anything more than they asked for, because they'll use it against you. I actually, as paranoid as I am, don't buy into that school. I am a believer in being overly inclusive, because often that older information will help set up the decisions that were done at a subsequent time. So I personally am a fan of an expansive approach to sending things in.
And we haven't seen, in doing these appeals, we haven't seen any judge who basically says, I won't look at anything outside of the date of service.
Right.
They are actually interested in what the story is, and what's happened before the date of service, which is maybe what's in question, is totally relevant as to the physician's decision on that date.
And knock on wood, I've never had a situation where sending in the additional records has caused new trouble. I mean, that could change, I suppose, but it hasn't happened yet. Now, one of the practical issues you run into, especially if we're talking kind of the ALJ process, we'll talk more about how ALJ hearings happen, but they're almost always now via phone or video conference. In fact, I have not done an in-person ALJ hearing since we've gone to the new system. So 10 years ago or something, maybe 9 or 8. But that's a logistical challenge, and you need to start dealing with that logistical challenge when you get the request for records. So number things. If you're a lawyer, you might think of it as kind of a Bates numbering process. You want to have a record that's easily referred to. At a minimum, use tabs. If you can break stuff apart, and so that people in different locations can easily find the same document. Another benefit of the pagination is that it is all too common for whoever's getting your information to claim you didn't send something, and at least you can prove that it was there if you've got numbered pages and stuff like that. Another kind of related thing is keep an exact copy of what you sent in. People often, to be frugal, think, well, we've got a copy of the medical record. We don't need to keep a copy. But whether you're producing electronically or in paper, whatever you're doing, you want to know exactly what went in, both so that you can see, like maybe you missed something. It turns out somehow the radiology reports weren't sent.
And it's totally a nightmare for someone who's helping you at a later stage, if you have a lawyer or a consultant, for them to say, what did you send in? And then you'd have to guess, or you have to pull back stuff from the medical records. If you have a copy, if you pulled all the relevant stuff at the beginning, then you can just make another copy and send it to whoever is helping you, and you're all on the same page.
So I'm going to get a thorough review by the physician. Now, Katie's going to talk about how to present the arguments, and one of the things I have really loved about doing these since she's come here is she's got a tremendous flair for organization and has really figured out a good way of putting the arguments together, and so I'll let her walk you through that.
So I think one rule of thumb is that whether you're going to use a chart or a book of exhibits or anything, you always want to have a cover letter. And the cover letter should, at the very least, explain what you're including with the cover letter. So if you're using a chart, your cover letter should say, there is a chart. It has claim by claim analysis. It has tabs that have exhibits, and they are all labeled. It should basically tell the person who's going to review the stuff how to review it and where they can find things. The cover letter, which we'll talk a little bit more about in a minute, should also have your basic legal arguments. You don't have to get into the nitty-gritty details if you have a sample of 30 beneficiaries that you're going to be talking about. But it should have your overall legal arguments, your specific requests about the hearing, etc. So then I think the big question that people struggle with is they have maybe 30 to 50 patients where the claims are in dispute, and you might even have multiple services for each patient. So you're talking like you might be making easily 100 to 150 different arguments that need to be made in order to cut down the overpayment amount.
And just to be clear, this is more in a case where there's multiple claims, not necessarily one rack.
Right. So we're in the multiple claims where they've extrapolated, for example, the overpayment. So in that case, you're going to have a bunch of medical records that you want to send in and make arguments about. You're going to have multiple beneficiaries. So I think so far the best approach I've found is to have a chart that's easy to read, and you have the name of each patient and then broken down into each service that's in dispute. And then for each line in your chart or each row, you have your specific arguments. And then if there's documentation that you want to refer to for those arguments, you have it very specifically numbered in tabs with page numbers so that basically the reviewer can look at your chart, they can see who the patient is, they can see what the service is, and they can go over to your little box and see this is the argument. And if they want to look back to your documentation, they can refer to the tab. I think in a lot of cases they don't even necessarily look at the tabs, but they're there in case they want to go see what you're talking about.
Can you highlight information in the medical record or do anything like that?
I would highlight information in the medical record if it's relevant. If it brings the reviewer's eye to what you're pointing to, do it. I think it's the fastest and the most efficient way to help someone understand your arguments. Basically, you want to assume that the person reviewing hasn't seen what you're presenting before, and make it as easy as you can for them because they'll be in a better mood, and that's always helpful when you're trying to win your arguments.
All right, so let's talk a little bit about the appeal letter. And actually, Katie's going to talk about this, but I want to interject. One of the questions I think you often come with is who should write the appeal letter? Do you want your lawyer to do it? Do you want to do it internally or externally? If you're in-house counsel, and our basic approach is we're fans of the teach a person to fish theory of life. If you get a good letter, okay, let's break our appeals into two kind of buckets again. There's the case Katie was just talking about, the large, multi-extrapolation cases. Those are weird, and you're not going to have a form letter for those. Each one of them is unique. And when I say weird, what I really mean is they're unique. Then there are the rack audits where they come in and they're looking at your short stays, and you've got 30 of those, but they're coming in one at a time. Here we're going to be focusing a little bit more on those. And I think it is possible to get a pretty good form letter that you then tweak. And I personally think it is advantageous to have Katie help put together that letter, and you get a really good one and you use it over and over, and she'll talk us through a little more.
And the other sort of not real secret, but thing that people don't think about is that racks all over the country are kind of looking at the same issues. And so we've helped develop these letters for multiple people who have the same problem that you do. And so honing those arguments is not hard, and using that letter across the board many people can use it. So you're writing an appeal letter, and it's going to be the one that will carry you through the first, second, and third process unless you win, which great, congratulations, then you don't have to go to the ALJ. So the letter should be short, terse, to the point. It basically, which is not short, terse, or to the point description, but it should articulate the legal standard. Now, what you think is the legal standard and what is the real legal standard is different than what the reviewer might think is the legal standard.
And I think this is one of the important, framing the argument in the appeal letter is really important. And we're going to go in a little more detail about short stays in a bit, but I'm going to take it right now. We believe that the standard for a short stay is whether the physician at the time of admission thinks the patient is going to be there either overnight or for 24 hours, and we'll get into that substance in a bit. Assuming that's the standard, what happens in the course of hospitalization is irrelevant, because the standard is what did the physician expect when he or she made the admission decision. So if that's the standard we're shooting for, a letter that describes in gory detail everything that happened over the course of the hospitalization is extraneous. And so you need to set the standard and then focus on what facts meet that standard. And I think that a lot of this is an area where we see a lot of the letters go wrong, and they're often they're too long because they're focusing on what the reviewer threw up, and the reviewer often threw up a bunch of chaff. And you got to sort through that chaff, pick what the right standard is, say, here's the standard, here are our facts, and stick to that.
So, for example, the opening line of one of your letters could easily be and should be, we believe the inpatient stay was necessary and should be paid because the admitting physician thought Mrs. Smith would be in the hospital overnight. So you start there, and then you explain why the admitting physician thought that. You don't need to have 2 pages of medical facts, and then you close with the same conclusion.
And I don't know if we did this anyplace else. And so one of the other issues that's coming up a lot right now is inpatient versus outpatient. Let's say you concede that your inpatient stay should have been an outpatient stay. What do you do with that? And you can, in the letter, concede that point. Now, gets interesting because there have been stories out there that some people are making that concession and then having the appeal dismissed on the basis that there isn't a legitimate dispute because you're not arguing that the inpatient denial was improper. And that's that analysis is just flawed because there is a dispute. There's a dispute about payment, and you are saying that you were paid the wrong amount, and that what should have happened was that the amount should have been, a non-zero. You should have been paid for the outpatient amount. To avoid that headache, some people will, at the first level, still argue that it should have been an inpatient admission. I think reasonable people could differ on the approach to that. But one thing you want to include in your form is that if you're denied on an inpatient stay, at a minimum, you should be getting the outpatient stay amount.
All right. So one sort of technical area that's very important that we've seen people get kicked out because they didn't include all of the information is what you have to put in your appeal letter. Besides, obviously, the legal standard and your arguments, there are regulations that say what you have to include. And so I've listed here what you need to include for your request for redetermination. This is going to be the same, these are the same items you need to include in your reconsideration, which is level 2, and also your ALJ request. I would note that different contractors in their letters to you saying you can appeal have different requirements for what you have to include. So what I would recommend is making sure that you've checked off this list here on this slide, and then also read the letter from the contractor that says, in order to request to appeal, you must include these items or this information. Because it's possible they'll say, you have to include our contractor's Medicare appeal number. Well, that's not really listed, that's not here in the list, but they might insist on that. So basically read the letter really closely, make sure you include these items on the slide and anything else that they want so that you don't get kicked out and so you have to call back and try to explain why you didn't include it and then risk basically not being able to move on.
What about this appointment of representative form?
The other thing that you need to have at each level, well, at least at the first level, and I would just recommend including it at all levels, is an appointment of representative form, which is a CMS form. I believe it's CMS form 1696. If you Google it, CMS appointment representative, it will come up. But basically it is if the provider has hired a lawyer or a consultant or somebody other than the provider itself to represent them in submitting the appeal letter, you need to make sure that whoever you're sending this to knows that. And so you have to make sure you complete the form, have the provider sign it, and then have the attorney or the consultant sign it, and send that in with every single level of appeal. We've submitted letters on behalf of people where somebody forgot to sign the form, where maybe the appointment of representative form was included, but they didn't see it, and they said, sorry, we contractor can't talk to the lawyer about this. We have to talk to the provider. Or even worse, we're going to kick you out. So it's totally important to have these little things, and they'll drive you nuts, but double check it, triple check it. Also, another area to double and triple check is the address to where you're sending it. This might seem really obvious, but every time it sort of gives me nightmares that I will send something to the wrong address. And the reason for that is because the letter that says you have a right to appeal has like 4 addresses, and they're all a little bit different. There's one address for if you want to just pay back the money. There's an address for if you want to, I'm trying to think, if you want to do like a rebuttal. There's an address for if you want to request records. And then there's an address where you have to send the appeal to. And it's totally confusing.
And
so you have to highlight it, circle it, make sure you send it there.
Highly importantly, that may not be the return, and usually is not the return address on the letter. So like if you look at the bottom of the first page and there's an address, that may not be it.
That's probably like the 5th address on the form. So make sure you have the right one.
Thing is addresses just changed at
Yes.
some levels. And so if you're using an old, like if you've got a form that you've been using in the past and someone carries forward a previous appeal address, it might be wrong.
The other thing you have to think about when you're writing this letter and sending it is making sure that you copy the right people. Now, you would think that the rules would be really clear on who you have to copy, but they're actually not. And I think since they're not clear and since the manuals don't offer a lot of helpful information, but since in many cases, the initial contractor who made the determination and the patient are considered people who would be affected by this appeal, and therefore they need to be copied on the correspondence. So this is who you copy. You copy the contractor who made the initial decision, the contractor from which decision you're appealing, if you're at like the 2nd or 3rd level, the patient, can send them a copy in the mail. I'm trying to think who else.
Well, I'm just going to interject there because this patient thing is an interesting one. Every now and then as a lawyer, you have these, oh, crud moments. So one of mine was when I had a contact that suddenly said, you need to copy the patient on this. And I thought it's interesting because I then went to a conference in Baltimore where all of the people who do these appeals were sitting together, and we'd all heard this at the same time.
Yep.
And every one of us went, holy cow, because no one had ever been asked to copy beneficiaries before, and suddenly you're being asked to do that. Just from a PR standpoint, it can be useful to develop a short letter, a cover letter that you can put together to put on to the beneficiary to say, look, you don't need to worry about this. This isn't going to affect anything you're going to have to pay. We're filing this appeal. We'll hold you harmless. So, at least if that's true, and in most of these it is, the beneficiary doesn't panic, in a very short letter, so that they can basically know that they can ignore everything that comes after that very short letter.
Use tracking if it's available. My assistant is very good at knows all this stuff. I know you can't necessarily get a return receipt if you send to a P.O. box. A lot of these things have P.O. boxes, so in that case, you want to try to send it as early as possible so that there's no doubt that it got there. So use tracking if that's available. Call to confirm receipt. I don't always call to confirm receipt, but if I'm pushed up against a deadline, then I think it's definitely worth calling later to make sure it got there. Because it's definitely easier. I think we've worked with contractors to have them accept things that maybe didn't get there on time than to find out 3 months later where nobody knows who you are or cares. So other sort of process issues that we'll talk about briefly. With the RAC appeals, there's a process where you can discuss and there's a process where you can rebut. Both of the discussion and rebuttal processes run from the date, I believe, of the demand letter. I have not had clients who have had a ton of, success in making the thing go away by rebutting or discussing the issue. I think this is used like if it's, maybe the RAC will say this was already paid, this claim was already paid, and you want to call and it's very clear that it wasn't. You can rebut these sort of like very factual.
Although I have to say, when I've had very clear situations like that, it still hasn't worked.
Right.
So I think I am over at the rebuttal process personally.
Okay. And they run more quickly. So the rebuttal process, I think, is 15 days. And I think the discussion period goes on for a while, but again, haven't had much luck with those. Requesting time extensions. I don't think I've actually ever requested a time extension, David. I don't know if you have. Nope. I wouldn't count on it at all, unless you've been involved in a natural disaster. First of all, the reason I wouldn't count on it is because it's really hard to get a hold of somebody who knows anything at these places. Whenever you're trying to call to stop recoupment, figure out if your appeal's been accepted, set aside like an hour on multiple days, because you might have to call back, because people, unfortunately, it's not very organized. So don't count on asking for a time extension, because I just don't think they're giving out that much.
Okay, so one of the other issues that comes up here is interest. The way Medicare works is that if you don't pay the entire recoupment within 30 days, interest starts to accrue. And the bummer, or I suppose and potentially the good thing, is that the interest rate is insane. It's somewhere north of 10% right now.
The last one I saw was 10.275%.
Yeah, so it's not prime plus. There's a rate. It appears in the Federal Register. I mean, it's been at times in the past up as high as 14 or 15%, but it's basically what you think a normal interest rate is plus 8%. Okay, so if you have any access to money, I mean, like from a loan shark, you're better off at that interest rate. But there is one thing to note. It is now pretty clear that if you win, you get interest on the money you put in.
Do you get the same rate?
Yeah, you should get the same rate. Now, this used to not be the case. This was the really sucky thing in the old days, was you did not get it. You paid interest if you lost, but you didn't, if you paid it in, get interest. And an appeal that, well, don't get me started in times where I felt like an ineffective lawyer, but now it seems pretty clear that you get interest if you win. So there's an argument for paying it in means that you'll, in essence, be getting interest at this high rate. If you don't pay and you win, interest is moot. So interest only matters if you pay it in and win, then you get your interest back. If you don't pay it in and you lose, you're way better off having paid in. If, like I said, if you can get money at anything less than 10%, you're better paying it in.
The other thing is, make sure you have this seems really obvious, but make sure you have a record of what you sent in and any correspondence, because sometimes people will choose to send in like half the amount because they think, well, we'll end up having to pay that, so we'll at least send that in and we'll reduce whatever interest, the amount that we're going to accrue in interest. But these things get referred, so the contractors deal with them, but then they also sometimes get referred to the Treasury. So you might be dealing with the Treasury Department and a contractor about what you've paid, and it gets totally confusing. And so make sure you keep a record of what has happened.
And Katie's reference to the Treasury is an important point, because one of the other things that will start to happen is you get threatening letters from the Treasury, basically suggesting that they'll take your firstborn children. And they're not supposed to be doing that. It comes really consistently in the bigger cases. And you can ultimately usually deal with those. In occasion, you wind up even having to do stuff like involve members of Congress and stuff sometimes to stop some of that. Okay.
We wouldn't wish this on anyone. All right. So you've got your redetermination. If you're thinking about appealing, it probably didn't go well at the redetermination level. I will say, don't get too bummed out if you don't win at the redetermination level. It's sort of like the same people
In fact, I'd put it another way. Expect to
not
it,
win. Right. It's the same people, kind of people who are looking at that as the first contractor that looked at it. So the second level is the reconsideration. This is also known as the qualified independent contractor. They're supposed to actually have some clinical people on this level, and actually we do have some success at the reconsideration level. So I think it's reasonable to expect that if you have a good argument, you might get some success.
In fact, I'd say most of the time you shave stuff down. I've had a few complete wins. I mean, I've been stunned. I had $1 million overpayment that went down to 0 at the quick, and you go, wow, that was really nice.
Right. So there's hope out there. So the timeline for requesting reconsideration is like 6 months. And I mean, that's a long time, and it's easy to forget about this. So mark your calendar, same lesson. But again, in order to make sure, so what happens is that the redetermination comes, and then the right hand that gave the redetermination, if you lose, says to the left hand, okay, you can start recouping now. After the 60th day. So you have this whole recoupment thing again, where you have to make sure you get in your request within 60 days. Otherwise, you're going to do the whole song and dance again about trying to get someone to stop recouping your money. And now it's even more confusing because you have like an additional Medicare contractor involved. Oh, yes.
And you can do the same. It's the same placeholder letter. If you need more time, you can send in the placeholder letter and do the same gig you did before.
And this is also a really important stage because this is the last time, according to the actual Medicare rules, where you can submit any new evidence that you think might be relevant to your appeal. The exception is if you can show some good reason later on, if you're trying to submit some new stuff to the ALJ as to why you didn't submit it earlier. But this is where you want to kind of sit down and say, okay, is there anything else that we might want to go in, because we're gonna have to give somebody a good reason later.
And so the important question here is, what is evidence and what is not? Because you can make new arguments, and so you don't want to get confused. Just because you haven't made an argument to the quick, you can still make it to the administrative law judge. It's evidence that has to go in. And the biggest sort of unknown are what about things like statistics? And judges have been quite liberal to date on allowing statistical evidence, and basically any test. You don't have a chance to testify until you get to the administrative law judge level. You can't at the quick. There's no hearing, and there's no real expectation that you'll put in an affidavit with here's what the testimony will be. And I've never seen a judge suggest that was the case. So so basically it's the paper evidence that you have to get in. It's not oral testimony or analysis on it. Now, that said, I think it is helpful. Like, if you want to make a statistical argument, I would make the statistical argument in the letter and explain that you will have testimony coming up, and more on that on the next slide.
I think you'll also find that one contractor might deny a claim when you're talking about these big, well, I guess it could be just one appeal, for one reason, and you might submit evidence at a previous level saying, no, actually there was an order for this. But then the next level will say, okay, well, fine, so there was an order, but it wasn't signed or whatever, which there's a whole legal issue with that. And so you'll need additional evidence. And so if you get to the point where the quick at the reconsideration level is saying, we're denying it for a new reason, you would have, we think, good cause, definitely.
It's clear. You've got good cause.
To submit to the ALJ.
Okay, so I want to spend a couple minutes talking about statistics. This doesn't apply to the individual rack cases you get, but anytime you have a bigger overpayment that involves sampling, you have a question. And the Shakespearean part is, to be or not to be, or is it much ado about nothing? And I have been struggling with statistics for a long time, actually since college, when I did well in statistics, but I believe that I got someone else's grade because I never really understood it. So I have been struggling with statistics since then, and I've got a theory, and I have nothing to back this up except anecdotal information. But my theory is that if you win on a challenge of the statistical sampling methodology, that you are more likely to have your win at the administrative law judge level reversed, or at least taken up to the Medicare Appeals Council, part of the Departmental Appeals Board. That's the next level up. So I based this in part, I had a case that was like a $3 million overpayment. It was a really big overpayment, and we had great arguments on the merits. The statistics were really interesting. Interesting is here a euphemism for awful. This is where the laughable comes from. So first question, what was the sample size? Well, this is a basic question. One document said the sample size was 90 claims. Another said 91. Another said 92. There were none that said 93, but another one said 94. You could not figure out the sample size from their stuff. And that was just the beginning.
That's the most basic thing.
Of the problem. I mean, so one of the things that you're supposed to be able to do is have the documents, it's got to be reproducible. No one could reproduce this. It was drivel, okay? So I'm figuring we're going to get reversed on the statistics. I was wrong. We lost on the statistics. But on this $3 million overpayment, we won on the merits on all but just under $3,000. $3 million, $3,000. What's the difference?
Pocket change.
Yes. So the more I think about it, think that judge was doing us a favor. I believe that the judge thought that if he had overturned the statistics, it would have gone up to the Departmental Appeals Board, or to the Medicare, to the MAC, and we would have faced the risk of reversal. And that by making his decision on the merits alone, it was less likely that we would face that appeal. And in fact, we didn't. Now, can I prove this? Not at all. But it's made me more cautious about making statistical arguments in cases where I think the merits are very strong. And so I often engage in kind of this question of how good is my statistical argument likely to be? How good are my merits? And then comes the challenge of finding a good statistician.
If you know one, we want their name.
Yeah, that's about it. They're expensive. They're hard to find.
It's hard to find someone who will explain things in layman's terms to the client, to you, the lawyer, and to the judge. And that is totally important.
And who also won't suddenly agree. I mean, often what happens, and this can work in your favor, but often when you get the statisticians on the phone, they want to kind of agree with each other. And so they'll kind of say, oh, yeah, I guess this isn't that bad, and they'll reach some middle ground. And sometimes the carrier statistician will do the same thing, but often it's your own expert. So I will say the statistical effort engaged in by the Medicare administrative contractors is often laughable. And I think, Katie, you were telling me about some changes in the manuals recently.
Right. So, and that's one point, is that all of the statistical guidance or rules out there for contractors, they're not rules, they're not law, they're manual guidance. And so that's what's hard to challenge about them, is because there isn't a hard and fast way that they have to do things. Sample size doesn't have to be a certain size. It's sort of based on these sort of principles that are in the Medicare manual, so not even binding. And actually they just totally revamped the section of the manuals about the statistics, and I fear took away a lot of what were sort of confusing points, but could be helpful to providers, and sort of whittled down even the guidance that you could use in making a statistical argument. So that's changed as of probably the last 9 months or a year ago.
And I probably should have brought an opinion to just read a paragraph or two, but reading the opinions is really depressing, because often they'll say something along the lines of, yes, this might not have been perfect, but it was good enough. And so where this comes up, and I am not a statistician, Katie's not a statistician, but there are all of these different issues. Are you going to stratify your sample? And a statistician that we used to use before he died, like to talk about the parable of the footballs and the fish. He would explain, if you are trying to figure out how much a football weighs, you really only have to weigh one. They're all the same. If you want to figure out how much a fish, what's kind of the average weight of fish, you've got this wide range, and you have to measure, take a much larger sample to get the same information. And so they'll describe this stuff. Well, one of the points that comes up is this concept called precision. And if you read statistical books, they'll talk about kind of the level of precision you need. And for many things out there in the statistical world, they'll talk about wanting a precision of 0.1 or below. All right?
Less is better.
Yes, less is better. It's kind of like golf. So there are some government publications that suggest a precision level of 0.25 is acceptable, obviously much higher than the 0.1 that's out there for other things. Well, so that's the first thing, is that a statistician will say anything above 0.1 is bad, and you'll get the government statisticians to say, or even the OIG, there's some OIG guidance that will take things up to 0.25. Well, we had a case where the precision was 0.51, I think. Was it 0.51? And so twice, I don't know if it works on a mathematical scale here, but way above the 0.25 from the OIG guidance. And the judge ruled upheld the statistical sample in that one.
Because there isn't a rule that says it has to be something else.
And so this is why, so sampling's a mess. I don't want to belabor this too much, but it's one of the reasons I don't necessarily spend a lot of, if I think I've got good arguments on the merits, I may stick with those and blow off the sampling.
All right, so you're at the administrative law judge stage. This is basically, you have 60 days after you get the reconsideration from the quick to request the hearing. At this point, CMS can start recouping, and there's no way you can stop it.
They often don't, for reasons I don't understand, but they can, and you cannot stop it. I feel lucky because I've had a bunch of situations where they haven't, and I don't quite know why not.
So I think the rule here is get your request in as soon as possible so you can get scheduled for the hearing as soon as possible, so the recoupment will stop and you can just be done with this whole thing, hopefully. Note that there is a requirement that you have over a certain amount in controversy to request an ALJ hearing. Right now for 2013, that's $140. So, okay. So you have a lot of choices about what type of review you want to request.
So basically, in theory, they tell you can do an in-person appeal, and that you can go to Florida, the hearings, there are only a few locations: San Francisco, Cleveland, Florida, and there's one other in the Northeast that I can never remember. I have never had a judge let me go. So I've always done them either. Sometimes I'll ask for them on the record if it's clear enough. I don't do that very often, but it's either going to be telephonic or video. I am a fan, and this may sound surprising, but I'm a fan of telephone. You may think video is better in person, but I like to be able to play footsie with my client under the table. And when I say footsie, what I really mean is kick them.
Stop talking.
If something's going wrong, I want to be able to say stop and make a face and symbol and gesture, and you can do that when you're on the phone. I'm also, by the way, a fan of trying to be in the same location as my client if there's a big dollar amount involved. Small dollar amount, I don't care, but if there's a lot of money involved, I want to be sitting in the same room as my client. I might go to the client, they might come to me, but we're going to be in the same place. But I've vastly prefer telephone over video for that reason. I don't think video gives you many up. You can't look at the records together. So we're gonna. So we're not going to spend a lot of time talking about the hearing process itself. Really, that wasn't really our goal in this webinar. We're going to be moving on in a second instead to substantive arguments. But I will make a couple of points about the hearing. There are some questions. So first, who are the participants in the hearing? And this is an area where I probably should pay more attention to detail than I sometimes do, but there are questions as to the ability of the MAC to participate in the hearing as a participant versus a witness and what they can and can't do. The reality is the judges kind of just allow often more than the rules might permit, and you have to raise this question of whether you're going to try to be a stickler and object or just go with the flow. I tend to be a go with the flower.
And usually the Medicare contractor says we're going to participate as a non-party, which basically means you can't cross-examine them.
Correct. So, all right. The prepping of witnesses, that's we're not going to focus as much on that here, but the most important thing for your witness to understand is the legal standard, because they need to know what the end goal of their testimony is, and I think people often forget that. And so I think you have to just really make sure your witness knows, for example, in a short stay case, that the standard is, what did the physician expect when they admitted him? And we had a question about that. We'll come to that one in a moment. All right. We're not going to talk much about MAC and district court. We haven't gone up there much, very infrequently. I've gone up to the Medicare Appeals Council several times, actually. So that happens. Those are usually on the record. So you don't make an argument, you write a brief, and you see what happens. And I have never appealed a case up there, but I've had cases appealed up there by the other side. And we've done relatively well, but I get nervous when you went up there. And then district court is expensive, and I have not yet had a straight-up overpayment case go to district court.
But we would love to go to district court on the short stay because we think we know the right legal standard and that it's not being applied throughout.
So the last thing we're going to do here is just talk about we're going to talk about time limits at the very end, but we're going to go through 3 of the most common legal standards. And we're going to do this very quickly, both because we don't have a lot of time left and because we've done some of these before. But let's just walk you through this one. If you haven't heard this one in gory detail, you need to. And if you have, you can zone out for the next 3 minutes.
And if you want to hear it, we have a webinar on it that David did spend a whole hour talking about it, and we can send it to you.
Nothing but this. Yeah, it was August of last year. Just send either Katie or me an email and say, I want the documentation webinar. But here's the key point. If it isn't written, it wasn't done is not the law. The E&M documentation guidelines are guidelines, and the way we know this is this statute. Well, that's part of it. No payment will be made to any person or other provider of service unless there has been furnished such information as may be necessary to determine the amounts due the provider. Note that the statute doesn't say you have to have information in the medical record. It just says you have to have information, and that means you can get the information through any source you want, testimony, anything you want, all right? So it doesn't have to be in the medical record. The next few slides are excerpts from a question and answer sheet that CMS, which was then HCFA, put out way back when I was a pup, back in 1995, that said, are the documentation guidelines required? And the answer is no. So like I said, we did a whole webinar on that. So the key lesson is if you've got some chart that's denying something because of crummy documentation, don't feel that and you agree the documentation is crummy, but you think the service was really provided, you have a basis to appeal, and you should. There are some asterisks there for certain circumstances, and in particular, there can be a teaching physician and an anesthesia thing. Medicaid can create some interesting issues, but, so there's some asterisks to know about, but generally challenge situations if you think the service was really done. How are you going to prove a service was done? Well, you can ask people like the physician. You can ask other people who were involved. You can look at schedules. There are ways of doing it. And the other webinar will go into that in gory detail. Katie is now going to talk about another of our favorites, short stays.
Okay, so we've been talking about short stays throughout here and what the standard is. And we think we've honed in on the right legal standard, and we think out there are a bunch of contractors who are applying the wrong standard or some that they just made up. So the question really is in these short stays is who is an inpatient and who is an outpatient? Now, you'd be surprised, but the statute and the regulations for Medicare do not define who's an inpatient or an outpatient.
Medicaid does, by the way. It has a statute that defines it very clearly, but Medicare doesn't.
So Medicare doesn't. So we're not even in the actual law anymore. We're in the manuals trying to wade through to figure out what the heck is an inpatient. Now, there are probably 4 or 5 sections within the Medicare manuals that sort of talk about who an inpatient might be. What David and I have found is that throughout all of those sections, there are a couple key principles. First, the determination of who is an inpatient is made by the admitting physician. It's not made by the QR person after this has happened, after this day has happened, based on what sort of care was provided. It's made by the admitting physician. And
there's a regulatory site for that, which we didn't include in here, but Katie and I did a webinar on this topic, I think in May of last year. And if you send us an email and say, send us the short stay webinar, we'll send you that one.
More than you want to know about this topic. So the second key principle, and that I think is almost even more important, is that the determination of who is an inpatient is made at the time that that patient comes to the hospital and needs care, not after the patient has been there based on what happened, but rather what the admitting physician thought at the time that they came. So this is just one of the first examples of a manual section that talks about how to make this determination, and basically says that a patient is considered an inpatient if formally admitted as an inpatient with the expectation going forward that he or she will remain at least overnight. So we think if you have an admitting physician who thought they were going to be there overnight, you won.
Well, at least you've got,
at least you have a really good
argument, because we're now going to go to the next one.
The next one, which is a little bit different, but again, carries these principles of the admitting physician and the expectation. In the orange highlighted language, physicians should use a 24-hour period as a benchmark. They should order admission for patients who are expected to need hospital care for 24 hours or more. So I think if you have 24 hours, then I have a hard time arguing against that.
24 hours, you're golden. Overnight,
you're golden.
Got an argument. 24 hours, you're golden. Now, the thing I would add is at least, I think there are a couple people in here from Alaska today. In Alaska, overnight and 24 hours are the same, or can be the same in like certain times of the year, not right now. No place else are overnight and 24 hours the same standard. But 24 hours, I think you're golden.
I think you're good. And then finally, there's this sort of third standard that talks about how basically it's up to the physician. It's complex judgment. It's up to the physician only after they thought about basically all these factors in the next few slides, what they need, what their history is, what sort of stuff they will need. But again, what they think at the time the patient comes.
And this leads to the next point, kind of our final substantive point, or substantive argument for appeals, which is the treating physician argument. And there is a principle in Medicare that if a doctor thinks something is medically necessary, there's a presumption it is. The presumption is rebuttable, but there's tremendous deference to the treating physician. And that is, I think, the strongest club in any Medicare case. If you've got the doctor on your side, that doctor's testimony, together with the statute, gives you a compelling argument that the service is supposed to be covered. And so there's this treating physician rule. We're not going to go in gory detail through the 2 case citations, which we include in the next slides, that just articulate the principle that the doctor is supposed to be the key figure in determining what happens. You basically give extra weight to the treating physician. It's interesting because there's some manual language that says that MACs are not supposed to recoup overpayments on medical necessity if the situation's ambiguous enough that the MAC had to get its own physician consultant to review whether the services are covered. And so that, as soon as they've done a physician review of something, you can arguably use this. Now, this only works if it's a medical necessity argument, but if it's a medical necessity situation, you can start to use this to say, hey, look, it was, I get a little sad or mad at myself for using this because I think that there should be more physicians involved in reviews. And so I don't like discouraging physician reviews. But what the heck, if they use a physician to review it, this is an argument that that's an admission that it's a close call and that at least on that case, you should not have to pay an overpayment. So there's also, another legal argument that's worth noting. There's a statute in the Medicare Act, and the citation is here, that says only a national coverage determination can change benefits. Otherwise, benefits are set out by the statutes unless it's promulgated as a regulation. And where this becomes important is it means the manuals can neither create nor limit a benefit. So that's just an important point to make, because often people are using manual guidance to try to argue you're not entitled to something, and this basically says that they can't do that. Backup for that are a couple of court cases that I've been lucky enough to be involved in which the government has said in briefs, and I love this, that a person relies on the manuals at their own peril.
That's a good one to keep in your back pocket.
It's a very good one to keep in your back pocket. It also depresses the socks off of me, because it means they write these manuals and then they try to claim that they're not binding. Okay, last couple of slides, then we'll deal with our questions.
All right, so time limits on recovery we could talk about for about 25 minutes. But I think the takeaways are that there, depending on where you are, statute, regulations, or manuals, there are multiple different time limits that have been set by Medicare on what a contractor, can recover. So starting with the statute, there are two sections. Actually, I should say there's also another argument that's in the statute that says a provider or a supplier who is without fault does not need to refund money. So that's there. Under these statute sections, there is a presumption that's created that you are without fault if the request for payment was made 3 years after the payment was made. So actually, that was just changed by the fiscal cliff bill to now 5 years. So basically, presumption doesn't help you until 5 years later instead of 3 years.
And it's 5 years after the year in which payment was made, which is really confusing, but it basically means it can go up to 6 years, because you look only at the year in which payment was made, and then you look at the year in which they're recovering. So
know that those are there. Now it's 5 years, so not as helpful.
We're going to blow through that one because there are better standards.
So then in the regulations, there are rules about when a contractor can reopen claims. So they can look at any claim within a year of determination for any reason. If they're going to open up within 4 years, they have to have good cause to do so. And then it says that they can open a claim at any time if there is evidence of fraud or similar fault.
So that's just important to note, is that if they're claiming there's fraud or similar fault, there's arguably no statute of limitations. That's sort of an open question.
And then finally, the manual language, which might be the best after the change for the fiscal cliff bill, is the manuals say that a contractor cannot go back beyond 48 months. So I guess the takeaway with looking at time limits is to try to find a time limit, try to find the shortest time limit that basically binds the contractor that's going after you, and run with it, because these are all legitimate authorities.
Now, so this is a Medicare one, is 48 months. So there are obviously there's Medicaid, and there you have to know what your state says, and states vary. New York, there is some case law that says Medicaid can go back for forever. That's kind of the extreme. But Medicaid can have limits. And then if you're dealing with private payers, there can be separate, shorter limits. We've really focused on Medicare today, but it's worth noting because sometimes you can find amazingly good language, like limiting it to 1 year in
your contract.
Yeah. Okay, last slide before we do our questions. The time limit on RACs. RACs are different than other things because there are special limits for RACs. And then within that, there are actually two different limits. So the statute puts a limit of 4 fiscal years on a RAC's recovery, but the statement of work says that a RAC can only recover 3 years from the date of payment. And I guess what we'd say is, well, let's focus on the statement of work and use that. And I'd say that a RAC can only go back 3 years from the date of payment. The tough thing is they've got the statute that lets them go back further, but I would grab that statement of work and use that and say that's the limit on how far back they can go. So we've got a few questions here, at least one of which has me marginally stumped. So first question asks about the standard and, when you say the standard is what the physician suspect at the point of admission. Please provide the regulatory authority for that. And if I would just say, I will send that person a copy of our May webinar to deal with that.
Yes. Interesting question, and I'm not sure I'm totally understanding, but it says, do you recommend a specific dollar amount for individual appeals or redeterminations? I think this person is asking how much you should be spending.
Actually, I think they're saying when do you let it go?
Oh, okay.
So I'll tell you my opinion on this, which is I am a bit of a fan of the lock the doors theory of dealing with the government. And what I mean by that is, and I've used this analogy before, if you've got a car parked on the street, you may know that people walk up and down the street lifting the door handle to see if they can get your loose change. And you have to make a decision, do you want to lock the door or do you want to leave the door open so someone can take the loose change? If you lock the door, someone might smash the window, but they're more likely to not take your loose change. I think you fight, I think that you want to demonstrate you're not a pushover. And so if you're right, I would consider appealing even small ones and figuring out a way to do it efficiently. I mean, it's a business decision, really, ultimately. But I do think that these overpayment things are a shakedown of sorts. And so I think if you have done nothing wrong, I am a fan of fighting. I know I had one client that did this, and it seems like it worked. I don't know that it works all of the time, but we spent a week fighting a whole bunch of cases, and after that, they stopped getting audited. Okay, so next one. And I'm going to turn to you on this one, Katie, because I don't know for sure the answer. If the patient is deceased, do you need to send a letter to the family? I think the answer is yes, but I don't honestly know.
I think the answer is yes. I think if you know the family or that you can get an address for them, I think send it, and you've discharged your obligation to notify the patient.
Okay.
One question is, how do you know what racks are looking at? That is a very good question, and actually is an answer that is put out there by the government. So each rack, so the racks are signed to different regions of the country, and a rack, I should say, is a recovery audit contractor. We haven't really explained who all these acronyms are, but they are assigned to different sections of the country, and on each of those contractors' websites, they have listed the issues that they are specifically looking at. So you can educate yourself before this whole thing even starts to figure out what the rack in your area is looking at and try to get on top of the issues so that if they ever come knocking, you know why and you can show that you've actually been doing things right.
Okay, last question is one. It is a good question, and it's a question I almost hate when people ask. What responsibility do providers have to refund dollars to private payers or individual patients, and how do the risk profiles differ from government refunds? And so the answer to that, and if you focus on this, I'm going to focus first on the overpayment situation. You know, if you've got an overpayment to the government, what's your duty to the patient? It isn't as statutorily clear. I will say this: if you lose the overpayment, I think it is harder to argue that you should be keeping the copayment from the patient. There are arguments to be made on small dollar amounts that you can arguably say it comes out in the wash. That argument is best. It is strongest if you write off small amounts that patients owe you. I mean, I noticed today a bill for $5 from a healthcare practitioner to our family. Well, if you're billing patients $5, you can't, I think, say we owe you $20. We're just writing it off. That doesn't work very well. I don't think that argument is going to pass muster. But if you say, look, if someone owes us, $7.75, we don't bother sending a bill to their house. I think at that point you can probably absorb a small amount you owe them. Otherwise, I'm more comfortable with the refund argument. It's not as clear statutorily, and a lot of it actually falls to state law. It's more state law than federal. Private pay, in the private pay world, your contract may require the refunds. I haven't seen many contracts that do that.
It's possible,
but it may. Let's see. So I don't know if that's helping at all or not. This is a headache, and I think. I don't think that there's a strong legal argument that says you don't have to refund to the patient. I think a lot of places exercise, and I think doing it on a case-by-case basis based on how egregious the facts are and the amount of money involved is actually something I kind of endorse. The bigger the dollar amount, the more I recommend refunding. So we've run over time a bit. So please fill out your evaluations. If you want to comment on anything from my bad jokes to the content of this information, please do. Remember, these webinars are free going forward. The next webinar, don't forget, is going to be a weird one in the sense of it may not be cut. It's going to be for different people in the organization. It's more for people who are responsible for dealing with your benefits, what employers need to know about healthcare. May is 340B. June, we're taking the month off. And then July is HIPAA. Katie, you got any closing thoughts?
Well, hopefully your appetites have not been quashed by this webinar and can go enjoy a late lunch. And
Pi Day tomorrow.
Pi Day tomorrow. And feel free to call us anytime. We love to talk to all of you about what's going on in your world.
Thanks much, and have a great day. and hopefully talk to you next month.